I'll try to speak a little louder and get a little closer when we get started, which will be in just a minute.
Okay.
I guess it is time now. Okay, yeah, I just want to look at the statute just a second before. Right. All right, is everybody ready?
Yes.
I'm ready.
Okay. All right, good afternoon. We'll call this Monday, September the 14th session of the Property Tax Commission to order. And we have the calendar before us. We've got one case that's previously been settled and another motion to dismiss that's been continued, and we have two. That was yours also, I think, Ms. Parrish. And then we have the CHR Sanford Square LLC motion to dismiss before us, and then we have one from McDowell County, which we'll hear after this one. I'm Bob Hunter, Chairman of the Commission. Normally to my left is Mr. Alexander Guest, but he is not here today. And then far back we have Commissioner Wheeler, who's the Vice Chairman of the Commission. In front of him we have Commissioner Peasley, and then over there Mrs. Michaud, Commissioner Michaud, and in the back our General Counsel and Secretary, Mr. Pelfrey, and we have Alexandra Bendette, who's our staff person here and operating the WebEx. And on our virtual site, we have Cynthia Rice, who is our stenographer. And I see that we have the parties' attorneys before us, Ms. Parrish representing Lee County and Mr. Anderson representing the appellate CHR Sanford Square LLC. So I think we're ready to go, and everybody indicated they could hear me. So if Ms. Parrish, you file this motion to dismiss, and we will hear from you at this time. And I believe you just, we don't see, and it was showing mute, but the mute looks like it's, there you are.
Can you hear me, see me now?
We can, yes, ma'am.
Okay, thank you. Sorry about that. Thank you for this motion. My name is Parrish, and I represent the tax office here in Lee County. And just so you all aware, the tax administrator is in the office with us. Michael Brown, the tax appraisal manager, Lisa Faulkner, and another attorney in the office, Jennifer Gamble, is also in our room. You just can't see them. So,
are you in-house counsel, or are you with a firm there?
No, sir, I'm in-house counsel.
Okay.
Thank you. So yes, the county filed this motion in July, asking the commission to dismiss the appellant's appeal because the appellant failed to timely appeal its valuation to the Lee County Board of Equalization and Review. The statutes 105-290 and 105-322 set out the procedural requirements that a taxpayer must follow in order to timely appeal a valuation set by the Board of E&R to the Property Tax Commission. And in this case, the appellant failed to timely appeal to the Board of Equalization and Review, and therefore did not receive a value from the Board of E&R before appealing to the Property Tax Commission. The appellants viewed the information they have provided. They haven't argued, and I don't believe would contest, that the Lee County Board of Equalization Review's adjournment date was April 17th of 2020. If you do need to hear any further evidence of that, Mr. Brown is here and can provide testimony or answer any questions from the commission. According to the affidavit of Ms. Cook on behalf of the appellant informally did appeal its tax value to the Lee County staff, and she admits to having email correspondence between herself and the tax office staff, and that would have been with Ms. Faulkner, between February and March 19th of 2020. As you can see in the exhibit that Lee County filed, Exhibit 1, Lee County Tax Office notified the appellant of its informal decision on March 24th, 2020, and that was by mail. That's the standard form of notification that our office provides of informal decisions to taxpayers. At the bottom of that letter, it states that to further appeal, that you need to appeal to the Board of Equalization and Review, and for the Board of Equalization and Review to consider your appeal timely. Your appeal form must be received by the board as of 12 p.m. or postmarked by the U.S. Postal Service by Friday, April 17th, 2020, which is the advertised date for adjournment. And that's to give our office and the Board of E&R time to timely appeals for hearing after the adjournment date. As you can see in Exhibit 2 that the county filed, the appellant mailed that same information filed in the informal appeal back to the Board of Equalization and Review, and that envelope that it was attached was postmarked on April 21st, 2020, which was 4 days after the adjournment date of the Board of E&R. Ms. Cook's affidavit indicates that she tried filing her appeal with the Lee County website, but that the website was down. But I don't believe that she failed to contact the tax office, with whom she had multiple emails with, to let them know that the email link was not, or that the link was not working. On April 24th, in Exhibit 3 that the county has held, the tax department subsequently mailed a letter to the appellant, informing the appellant that its appeal to the Board of Equalization and Review was untimely because it was received after the board had adjourned. The Board of Equalization and Review, according to 105-322 G2, requires for the board to review and hear taxpayer reviews of the listing of the taxpayer property, and that a request for hearing shall be made in writing to or by personal appearance before the board prior to the adjournment date. The board has to have an adjournment date, and that date must provide some for the board and the tax office and the public at large to know when they must file an appeal, or else there would be no way of monitoring that date. If there wasn't a postmark date cutoff, then what would stop any taxpayer from filing a late appeal and then come forward and say, well, we placed it on the date that that you had adjourned? There would be no way of us knowing that when we cut off 5 days late or 6 days late. And it's important for the board to hear timely appeals and to do so in a just and equitable manner. I just want to briefly, I have an email, if I need to email to Mr. Pelfrey to provide to the board or to opposing counsel. There was just 2 cases. One was the NRA Appeals of Louisiana Pacific Corporation. That's 208 NC App 457. And in that case, that was dealing more with whether or not a appeal to the Property Tax Commission was timely. And in that case, the court ruled that that appeal was jurisdictional, was not timely, and the Property Tax Commission didn't have authority to hear the case, which I believe in this matter, failing to appeal properly to the Board of E&R, going to the PTC would also be jurisdictional. And then the Dixie building case, that's came from a Guilford County Board of E&R from 235 NC App 61. The court there, they had an adjournment date on July 2nd and was formally appealed in November of 2013. And there, the court indicated that the Board of E&R can set reasonable schedules for hearing requests to ensure that all timely matters are heard. And for those reasons, we're asking the commission to dismiss the case, and I'm happy to answer any questions.
Okay, any commission have questions before we hear from Mr. Parrish? Okay, Mr. Beasley? Okay, can you hear me okay? Can you hear me okay?
Yes.
My question is does the tax department require one of their forms to be used in order to begin the appeal?
No.
Or can people just send in correspondence requesting?
I verified with the tax office that I believe they would have taken an email. If someone had an email and said, you know, the link wasn't working, and take.
I think she froze.
Yeah, we lost you just for a second after you said they would consider that and streaming was interrupted. So you want to repeat that?
Yes, sir. I apologize. I have asked the question to our tax office if there had been an email just indicating that they would like to appeal, say the link was down or wasn't working properly, they would have taken that to the Board of E&R as a timely appeal.
And I have one other question. Does your client have an opinion as to whether the link was in fact not working?
We were able to look and the link was working the date of adjournment, and we actually had 2 appeals filed. I think the latest one was at 11:57. Now, I believe Ms. Cook indicated that she tried on April 16th, and I don't have any indication whether or not it was working.
Other question, Ms. Shaw? Mr. Shaw.
Were there any calls from the taxpayer during this time?
And I'm aware of. No,
You said that no emails. Were there any calls?
any
Telephone calls that you know of?
Not that I'm aware of.
All right, other questions before we get to Mr. Parrish? Okay, Mr. Parrish, you filed a motion in response to the motion, or you filed a response to the motion to dismiss, and so we'll hear from you at this time.
Thank you, sir. I represent the appellant C.H. Sanford Square LLC. I'd like to just briefly review the facts and then speak to the law on the subject. As far as the facts, we have an affidavit from Kelly Cook, who is the director of operations of Azalea Management, which is the managing agent of the taxpayer. The principal office of Azalea Management and the taxpayer is a principal office in Buncombe County, North Carolina, about 3.5 hours west of Lee County. This involves 6.39 acres that are listed and assessed in Lee County. There was an informal appeal process. During the informal appeal process, there was substantial email traffic back and forth between the taxpayer and the county between March 24th and March 19th. And towards the tail end of that period, we entered the pandemic. And on March 10th, the governor issued a statewide state of emergency, and shortly thereafter shut down schools. Beginning March 16th of 2020, the taxpayer and its managing agent closed their offices, and all the employees began working remotely from home with only a clerical employee entering the office to try to distribute mail in the right direction. On March 26, 2020, Buncombe County issued a stay home, stay safe order requiring residents to do certain essential business or essential activities and ordering the closure of most businesses. On March 27th, the governor entered a stay home order requiring most businesses to close beginning March 30th, 2020 and extending through most of April 2020. Lee County entered a notice of informal appeal decision, but despite the frequent email traffic that had occurred to that date, no copy of that was sent by email to the working remotely employees of the taxpayer. Instead, by March or on March 30th, the notice of informal appeal decision arrived by U.S. mail at the office, which was closed due to the pandemic and the government orders. A clerical employee checking the mail was able to distribute that to the decision makers of the taxpayer around April 3rd. The notice of appeal did indicate that appeal forms could be completed online or an appeal form could be downloaded online. Attempted to appeal online, but at the time she tried on April 16th, which was before the date of adjournment for the Board of Review, the link would not work. The link would not function. She was unable to appeal or to download the appeal form. So she had to modify the appeal form that she had used for the informal appeal. And working remotely out of Henderson County, which is adjacent to Buncombe County, she went to a United States Postal Service blue collection box that was near her home in Henderson County, North Carolina. And on April 16th, 2020, before the adjournment of the Board of Review, she made the request for an appeal hearing in writing to the board by placing the appeal into the United States mail. I do not know. I've read a lot of articles this year about what's going on with the United States Postal Service and difficulties they're having and concerns that leaders at all levels have about that. I do not know why, but for whatever reason, the United States Postal Service took possession of, accepted this mail and took possession of it in Henderson County, North Carolina, presumably on the day after it was placed in the collection box, April 17th at the latest, maybe as early as April 16th. Did not postmark it on when it took possession, did not postmark it when it began processing it, did not postmark it in Henderson County, did not postmark it in North Carolina, did not postmark it until it had routed this piece of mail out of state to Greenville, South Carolina. And 5 days after the mailing, out of county, out of state, they finally put a postmark on it. The postmark reads April 21, I believe, which was 5 days after the mailing. Now, the question on the motion to dismiss is, did the taxpayer make the request for an appeal hearing in writing to the board in a timely fashion by placing the appeal in the U.S. mail before that adjournment date, or did it have to be postmarked by the United States Postal Service in order to be considered timely? Looking at this, 105-322 governs the appeal procedure for appeals to the Board of Equalization and Review for the county. And that reads, a request for hearing under this subdivision G2 shall be made in writing to or by personal appearance before the board prior to its adjournment. There's nothing further in 105-322 to elaborate on or define what it means to make a request for an appeal hearing in writing by that date. In particular, there is nothing in that statute that says that it must be postmarked by that date. There's a reference in the motion to dismiss and a reference this morning to 105-290, but 105-290 is inapplicable. That applies to the procedure for appeals to the Property Tax Commission from the county. Nothing in that statute governs the procedure, initial procedure to the County Board of Review. So that's inapplicable. By juxtaposition, that statute, which applies to Property Tax Commission appeals, does expressly and specifically require a postmark stamped by a particular date in order for the appeal to be deemed, quote, filed by a particular date. That is language is not in 105-322, and it's also different from 105-322 because it uses the terminology filed as opposed to made in writing by a particular date. The timeline is also different procedurally. So we can't look to 105-90, so that puts us back to 105-322. Now, the county implicitly concedes that mailing by the adjournment date is sufficient for the request for appeal hearing to be made in writing by the cutoff date. However, without statutory basis, without basis in the case law or the law, without basis in any county ordinance that I can locate, the county arbitrarily argues that, well, to make a request for appeal hearing in writing before the adjournment date by U.S. mail, it has to be postmarked by that date. That's not in the statute, not in the ordinances, that's nowhere. So the question becomes, when the agent of the taxpayer in the middle of a pandemic, where the governor orders have offices shut down, where the United States Postal Service is having the difficulties functioning that it is, did this taxpayer, within the meaning of 105-322G2, make its request for an appeal hearing in writing before adjournment in a timely fashion by placing the mail in the United States mail before that date? And we would contend it does. You know, I don't know, as far as, you know, a slippery slope argument or otherwise, I can only deal with what justice militates in favor of in this case. In this case, whatever reason the U.S. Postal Service had for delaying the postmarking, it is undisputed and it is established by the affidavit of Ms. Cook. And there's nothing in the record or otherwise out of the record to question the credibility of Ms. Cook. But she establishes by her affidavit, and it's undisputed, that she put the notice, the request for appeal hearing into the possession of the U.S. Postal Service a day before the adjournment date of the Board of Review. So on that basis, where the taxpayer there's nothing on the website, there's nothing in the notice that says if you can't complete the online appeal, if you can't download the form off of the link we've provided, instead of mailing it, as we've told you, as we've indicated to you in our notice of informal decision is the proper way to make an appeal, you should also do something by email, or you should also do something by phone call. There's nothing in the law, nothing in the notice of informal appeal decision that would have given the taxpayer any kind of notice or hint that making an email or making a phone call would have been deemed a sufficient appeal. The only reference in the notice of informal decision was to appearing in person, doing it online, or doing it by mail. And so it was not practicable, if not illegal, for the taxpayer to make the trip to Lee County to make a personal appeal. The online appeal was not working. And so the only other option provided by the law and provided by the notice of informal appeal decision was to do it by mail. The taxpayer did that, and the taxpayer should not be penalized because the U.S. Postal Service decided to route the mail out of state and let several days pass before placing a postmark. I'll be happy to answer any questions that the commission has.
All right, questions for Mr. Parrish? Mr. Anderson, I mean.
So you state as fact something that I don't have any evidence in front of me of, and that's that the Postal Service sent this out of state, routed it somewhere, the Postal Service in your area was having difficulty, but I don't see any evidence of that.
Okay, I guess I heard two questions. First, as far as where this was mailed, David of Ms. Cook establishes as fact that it was mailed in Henderson County, North Carolina on April 16th, 2020. The motion to dismiss provided by the county includes a envelope, and that envelope is the envelope that included the request for appeal hearing. And at the top of it, the postmark itself reads, Greenville, South Carolina, 21 April 2020. So the affidavit of Ms. Cook establishes that it was mailed April 16th in Henderson County, North Carolina. And the attachment to the county's motion to dismiss establishes that the postmark was not affixed until it went to Greenville, South Carolina on the date of April 21. As far as the difficulties of the U.S. Postal Service, I was speaking more broadly. I read an article last week about a contractor who was emptying a tractor trailer of U.S. mail in a parking lot and was discovered doing that. I'm speaking more broadly terms of the problems that the U.S. Postal Service has been having over the last few months nationally. And I do not have anything in the affidavit that speaks specifically to that. That's just judicial notice.
I have a question for Mr. Anderson.
Mr. Anderson, this is Commissioner Wheeler.
Yes, sir.
It appears to me that management, the notice was at their office. According to Ms. Cook's affidavit, someone from management's office emailed a copy to her on April 3rd, correct?
Yes, sir.
I guess my question is, between April 3rd and April 16th, nothing was done.
Not until April 16th. That is correct. I think there was internal assessment to try to determine whether it made sense to appeal. We know at this point we have an updated appraisal that shows that the value of the property is closer to 2.6 million and the 3.9 substantially exceeds the value. But as far as actual action to proceed with the appeal, to trigger the appeal, that was not done until April 16th. That's when the online attempt was made. That's when the envelope was placed in the U.S. mail. Between April 3rd and April 16th, or April 15th, I guess would be more accurate to say, through that point, dealing with whatever other issues they were dealing with, specifically with regard to this, I think management was trying to evaluate the decision and make a decision about whether to proceed with the appeal.
All right, thank you.
Yes, sir.
Other questions, Mr. Anderson? I have a question for Ms. Parrish and then maybe for Mr. Anderson. Ms. Parrish, first of all, let you reply to his argument about 290 not applying and 322 and what the requirement under 322 is.
Yes, sir. I agree. I mean, the 290 sets out the procedure requirements to appealing to the Property Tax Commission. I just referenced it by way of there's a way you must follow to get to the PTC, which does indicate, as Mr. Anderson stated, postmark date. And under 105-322 G2A, when it indicates that the request must be in writing or by personal appearance before the board prior to its adjournment, but the board still has to have some way of knowing what that cutoff date is. It needs, if it's not postmarked and if it's not brought in by personal appearance, then what is it going to take for anyone to come forward and say, hey, I stuck it in the mail the day of adjournment on April 17th. So that is the notice that in the informal letter that indicates that it has to be postmarked by that date. There was, I believe at that time, we had a Dropbox outside of the office as well that someone could have locally brought over the appeal to ensure that it was submitted timely.
All right, let me ask you, the statute says before the board prior to its adjournment. The notice says prior to the notice of adjournment. Had the board in fact adjourned on April 21st?
Would you mind if I asked the administrator?
Sure. Yep.
Did they adjourn on the 21st? I mean, on the 17th. Yes, the board adjourned on the 17th and then set up the hearing. You know, any hearing that's filed by the 17th, then we set up for hearing after the adjournment. Yes, that's correct. Right, Michael.
So,
okay.
So you're saying they adjourned on the 17th and then they reconvened and heard hearings? Is that what you're saying?
No, they did not reconvene. They just set hearings after the adjournment date to hear those hearings. Set dates to hear the appeals. I apologize.
Okay.
That makes sense.
What do you say about the requirement about the being filed and his argument about the postmark?
Well,
versus what it says in 322.
Well, there still has to be some way for our board, if someone is not going to come by personal appearance, but they're going to do in writing, it could have been emailed as well. But if it's going to be mailed, there has to be some cutoff for our board to know what is considered to be timely. Whatever, or staff would ever know what is considered timely appealed at that time, if there's not a cutoff, a postmark cutoff date.
Well, and obviously the board needs that information. Of course, the taxpayer needs to know definitely when the cutoff date is, and he's arguing that that's a different standard than under 290. But, all right, Mr. Anderson, what would you say in reply to her response?
I think the statute sets what the cutoff date is, and that the statute sets the cutoff date for the board to determine whether it was made in writing prior to adjournment. And if the board had held a hearing they could have taken evidence as to when the taxpayer made in writing this request for appeal hearing prior to adjournment. If they had had that hearing, they would have determined that the taxpayer did timely make this request for appeal hearing. And if there was some other taxpayer somewhere who had made in writing their request for an appeal hearing after April 17th, after the date of adjournment, and that was determined by the Board of Review at its hearing, then it would be in a position to justifiably dismiss that appeal at that time for being untimely. But, you know, there's no requirement of postmarking in 105-322. There is a time requirement, and if the Board of Review had accorded us a hearing, they could have elicited the testimony to establish that we timely made the request for appeal hearing. And we'd like that opportunity now. We'd like the opportunity to go before the county board, establish that as fact through our agent, and then proceed to have this appeal determined based upon the merits.
Ms. Parrish, you indicated, I guess you talked to someone. The notice says the advertised date of adjournment. The statute doesn't say that. Did in fact the board specifically meet on April the 17th and officially adjourn that date?
Yes, they officially adjourned, and then any appeals that were timely filed later set for hearing to be heard for a timely hearings.
Can you ask your tax supervisor, do they actually have minutes of of a meeting and adjournment on that date? Or are they just saying that that's the dates that's advertised?
The tax administrator is looking at it right now.
Okay.
Yes, sir. There are meeting minutes that were signed last week when the board met again, and it said that the Board of Equalization Review met for the purpose of adjourning the board on Monday, April 17th, 2020 at 11:45. The meeting was called to order at 11, it says members attending electronically included Chairman Michael McDonald, Erica Glover, Herman Morris, George Watson, and House four staff members present were Michael Brown, clerk, and then Whitney Parish County Attorney. The meeting was called to order at 11:45. The following appeals were heard, and there were none due to the COVID. And then motion was made to dismiss the meeting by Herman Morris, seconded by George Watson. The vote was unanimous, and the meeting was dismissed at noon.
Okay, so you have those. You may want to submit that for the record, just so we'll have that. Mr. Anderson, would you like to say anything else? Or Ms. Parrish, you have anything else to say before?
No, sir. I'll just note that that was signed last week on September 10th. Michael will address or scan it and send it to Mr. Pelfrey for the record. And that was the last time we met to hear some other hearings.
You lost me there. Say that again, please.
And that was just when we met last week to hear some hearings.
But when I'm talking about the date of April the 17th, those minutes is what I'm talking about. You'll send those?
Correct. Yes, Your Honor. Yes.
Okay, okay. Anything further from you before Mr. Anderson?
No, sir.
Okay, Mr. Anderson?
I'm sorry, I may have missed this. Those minutes before me. Was there a day? Did that stipulate Friday, April 17th?
She's scanning it now. If y'all like, we could. It'll take us just a quick second. We can email that out if everybody would like that.
Okay, thank you.
Mr. Pelfrey, I know Mr. Brown has your email. Mr. Anderson, can you, if I have it, I apologize. What's your email address?
It is Philip with one L, Philip, at longparker, longparker.com.
Okay. That will be coming through from Mr. Brown in just momentarily.
Okay, it's going to go to Mr. Pelfrey's.
Yes,
Sure.
Mr. Pelfrey.
Yes, Mr. Fisher.
It
So in the county's denial of your hearing, did you actually have an opportunity to go in front of them to pose the question, yes, you can hear this? Or did they not agree to hear you at all on the motion? Tell me a little bit more about, was it a summary dismissal? Or did you actually get to appeal in front of them and be able to make your argument?
To my understanding, Lee County just simply provided a summary, conclusory notice of decision declaring that we had not timely made the request for appeal hearing in writing. We were not accorded any notice, any hearing, due process to demonstrate that we had made the request for appeal hearing in writing prior to the adjournment.
You want to ask Ms. Parrish?
Yes,
Well, is it the county's position that they don't have jurisdiction to hear it at that point?
Yes, sir.
And what's your basis for that argument?
I'm sorry. Our standard practice is that if an after the adjournment date, then the tax office notifies the taxpayer at that time that the board has adjourned the session, and they are not that I'm aware of, are ever brought back in front of the board for hearing on that. That's been our standard practice.
So this letter, I guess, Exhibit 3 goes out, and just the taxpayer, there is no opportunity for a hearing.
Yes, sir. Yes, sir.
We'll take a short pause. Oh, wait a minute, Mr. Anderson, you have something else?
Yes, I just received by email the minutes, and I guess there are a couple of anomalies. The first line of the minutes says that the Lee County Board of Equalization Review met for the purpose of adjourning the board on Monday, April 17th, 2020. And April 17th was a Friday. So I don't know if that's supposed to say Monday, April 20th, or if it's supposed to say Friday, April 17th.
Oh.
But then it is signed by J. Michael McDonald and Michael Brown Clerk on September 10th, 2020, so that it was not made contemporaneously, but was evidently made, I guess, at the end of last week.
Yeah. If I may.
Go ahead.
Okay,
Go ahead, Ms.
sorry.
Parrish.
I'm sorry. It should say Friday, April 17th. We apologize for that. It was Friday, April 17th that the board met. And at that time, the minutes were signed last week when they were approved, when the board met to hear some other hearings on due to the COVID for hearings, and that's when they were signed. So that's the date that the chair signed it, and then Mr. Brown, being the clerk, as well signed it. Yeah, it was the first
they
time. We
meeting?
had, I'm sorry.
Well, maybe you were going to answer it. Did they meet between April 17th, whatever that date was, and September the 10th?
Sir,
With any meetings of the board?
No, sir. That was the first meeting of the board since the adjournment. They were waiting for able to meet in person to hear. There was I think there was 3 matters, and only 2 were actually heard. One was a consent matter. They were waiting to be able to meet in person.
Okay. Have you gotten it yet? It hadn't come to Mr. Pelfrey yet. It probably gets filtered to the Department of Revenue security system, do you think? Yeah.
Mr. Brown will send it in.
Well, he's got it, so I guess he's told us, and you've told us what it actually shows on its face. I think the Department of Revenue probably filters things that comes in, so it may be a little while before he gets it. But for the record, if you'll send it in,
Yes, sir.
a hard copy, I guess, so we'll have that. Other questions? Anybody have another question? All right. Hearing none, we will go into executive session and discuss this matter, and we will be back with you when we have a decision, which I anticipate would be probably within 30 minutes, but we'll see. If it's going to be longer than that, we'll probably let you know. Okay?
Thank you.
I'm off the record.
Yes, sir. I can hear you now. I can hear you now.
Okay. And Ms. Rice, can you hear me?
Yes, I can.
Okay, we're back on the record. All right, commission has reviewed the arguments of counsel and the affidavits and the responses in the file, and has voted 3-1 to deny the county's motion, and we'll be sending it back for the taxpayer to be entitled to a hearing on value. And we'll be getting out an order sometime before too long. Okay? Thank y'all very much. We appreciate it. Excellent job on both sides. Thank you.
Thank you.
We're going to take a short recess before our next case, and we'll come back in 10 minutes and take that up. We've got people online. Yes, Ms. Parrish.
Sorry, I just was gonna, I think the McDowell County has my name beside it. I just was gonna make sure y'all knew I wasn't on, representing the county in that case.
Okay. Yes. Yeah, it's on here correctly. Mr.
Okay,
Coates
thank
is on
you.
here, yes. And I know Mr. Coates, and I'm from McDowell County, and I know Ms. Parrish is not you.
Okay, thank you.
Thank you.
Thanks.
Bye-bye. All right, do we know if they're on?
Statement that he takes about a month ago. His voice has changed and is running today until 4 o'clock in the morning. I will.
Ms. Rice, are you back on? Can you hear me? No, she's muted. Ms. Rice, if you can hear me, you need to unmute.
I hear you, sir.
Okay, I can, all right, we don't see you, but we hear you, Ms. Rice. And, Ms. Wiley, you're still muted. You need to unmute if you can hear me. Ms. Wiley, can you hear me? If you can hear me, please unmute. There you go. I think you did then.
Can you hear me? Can you hear me?
Yes, we can hear you now. We don't see you. Do you have a camera?
I do not. I do apologize. We tried to have this set up in our conference room, and our IT department could not get it connected.
Okay, all right, well, maybe if we have another one, or sometime you'll be able to get them to get properly connected.
Yes,
Tell your
sir. We're
county,
going to work on that.
tell your county manager, Mr. Wooten, he needs to get his IT people to be able to. Modern world now, we're having to do all this stuff, but we didn't have to. Is Mr. Coates with you, Ms. Wiley?
Yes, sir, he is.
Mr. Okay, thank you. Good to hear from you, obviously. And here's some people from the county. Mr. Coates, you filed a motion to dismiss in this matter, so we'll hear from you at this time. This is the Monterey appeal of Northgate Inc. LLC, 19 Property Tax Commission 0386, 2 parcels.
Yes, sir. Thank you. Notice the decision in this case was dated July 10th, 2019. Actually mailed 2 days before that, but on July 10th, 2019, it was mailed to the Northgate Investments LLC at P.O. Box 671, Marion, North Carolina. And then a notice of appeal and application for hearing was signed and dated August 13, 2019 by, looks like the Mr. Montez, who I assume is a partner in the, or manager of the corporation. So that is clearly more than 30 days from the date it was mailed. So we believe that the dismissal is in order.
Let me ask, before we get into questions from commissioners, is anybody online representing Northgate Inc. LLC? So I'm told that nobody else is online. Have we had any communication from them, Mr. Pelfrey?
Nothing since the initial.
Okay. All right, questions from commissioners?
Taxpayers will be online?
Mr. Pelfrey, were the taxpayers notified to be?
Yes, sir. The taxpayers were notified to be here, and I realized I did not have my microphone on before for the previous question, but my response to about whether or not we'd heard from the appellant was that we have received nothing from the appellant since the notice of appeal was filed.
All right, questions from commissioners? Mr. Peasley?
What instructions, if any, are given to the taxpayers on how to join the WebEx? Or are we sending them a link?
Yes, sir. Mr. Peasley, in the notice of hearing, there is the date and time of the hearing. There is an online meeting link. It's kind of lengthy, so we tell them if you'd like to have it sent to you electronically to email us at the ptc@ncdor.gov email address. And that does happen. We do send out the link and the password by email. It would be pretty long to have to type it in, but of course that's also an option. But yes, we send them all the meeting information in a way to get that electronically. And of course the phone number and email address and everything else is available for any questions.
All right, other questions? Do we want testimony from the tax assessor regarding the mailing or anything? If the taxpayer is not here. All right, okay. All right, other questions or comments from any commissioners? Mr. Coates, anything you want Ms. Wiley to say?
For the record, she's the clerk to the Board of Equalization and Review, And I'll just ask her if she in fact did mail a letter on July the 10th, 2019. Is that correct?
Yes, sir. The letters were dated and mailed, on July 10th, 2019.
And that indicated that he had 30 days from the date of your letter to appeal. Is that correct?
Yes, sir.
And to your knowledge, he's came in and paid the 2019 taxes, that this was the subject of the appeal. Is that correct?
Yes, sir. He has paid his 2019 taxes.
Okay, well, that's helpful. Normally, we like to either have a testimony as to the mailing of the notice or an affidavit, so we've got something for the record. So that's good. That clarifies that. Anything else, Commissioner? Mr. Wheeler?
Just from Steve, just to make sure, it said the application for hearing dated August 13th. It was not postmarked, right?
I don't know the date it was postmarked. I know that the date.
Just a minute, Mr. Coates. Just 1 minute.
No, this question's from Mr. Pelfrey. I know it says it was stamped by DOR on the 16th, but when we received it, did it have a postmark on it?
Okay, I see what you're saying.
Do we have the envelope?
Here we go. Yes, sir, Mr. Wheeler, there is a postmark on the envelope and it is for August 13th. It was actually received by DOR on August 15th.
Does the statute read when it's postmarked? And if it's not postmarked, it's the date received by the DOR or the commission?
It's actually the opposite of that. The date filed is the date that it is received unless there is a postmark with an earlier date.
Well, that's what I asked you. You do have a postmark, right?
We do.
Of August 10th.
So the postmark says
I'm sorry, August 13th.
Right. It was actually,
But wouldn't that make it timely?
it came into the office on August 15th, but it was considered filed 8/13. What is the date of the?
If it was mailed July 10th and it's postmarked,
No, sir, because if the notice of decision was mailed on July 10th, then it would have been due in our office by August 9th.
gotcha. Okay, thanks.
Any further questions? If none, all right, do we need to go into executive session? All right, so we'll go ahead and vote on this. Do I have a motion? Do I have a motion to allow the county's motion dismissed by Vice Chairman Wheeler, seconded by Commissioner Michaud? Any discussion? Hearing none, all in favor of the motion, say aye. Aye. And it's unanimous. Thank you, Mr. Coates, and so Ms. Wiley, appreciate it. And Fred, I guess I'll see you before long.
Yes, take care.
Uh-huh.
Yes, sir.
All right, that takes care of our cases, so I think there's nothing else for the record. We've got some administrative things to talk about, I think, Steve, but we can go ahead and go off and back into private session, I think. Practice session.
I'm off the record.
I mean,